When the framers built our government, they gave the executive its sword, the legislature its purse, but the judiciary? They gave it something far more dangerous, the power to decide what the law means. As Alexander Hamilton warned in Federalist No. 78, the interpretation of the laws is the proper and peculiar province of the courts. Without it, the Constitution itself would be, in his words, a mere recommendation. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. The framers' choice of words matters. Shall be vested, not may, not should, but shall. Under the failed Articles of Confederation, there was no national court system. Each state interpreted federal law, or ignored it, as it pleased. The result was legal anarchy. Alexander Hamilton warned in Federalist No. 22 that without a unified judiciary, the laws of the United States would be, quote, a dead letter. The Constitution fixed this by creating a single highest court, one Supreme Court, to speak with final authority on questions of federal law. This was not just structure, it was survival. Without a final arbiter, the Union itself could fracture over conflicting state rulings. While the Constitution creates the Supreme Court, it leaves all other federal courts to Congress, such inferior courts as the Congress may establish. This is why the very first Judiciary Act of 1789 set up district courts and circuit courts. Over time, Congress has reshaped that structure again and again, adding courts for a growing nation, merging them, or changing their jurisdiction when needed. James Madison explained during the Constitutional Convention that giving Congress this power kept the judiciary adaptable, but prevented the multiplication of powerful courts without oversight. The People's Branch would decide where and when justice would be administered. Then comes one of the most debated phrases in the Constitution. Judges shall hold their offices during good behavior. In plain language, a lifetime appointment, unless removed by impeachment and conviction. Hamilton, in Federalist No. 78, defended this fiercely. The complete independence of the courts of justice, he wrote, is peculiarly essential in a limited constitution. Life tenure, he argued, shields judges from the shifting winds of politics. They could rule by law, not fear of losing their job. But lifetime doesn't mean untouchable. The good behavior standard means judges can be impeached for misconduct. In 1804, Justice Samuel Chase was impeached for political bias, though acquitted by the Senate. The precedent was clear. Removal is possible, but only for corruption or serious wrongdoing, not unpopular rulings. Finally, the Constitution guarantees judges shall receive a compensation not diminished during their continuance in office. This shield came directly from colonial memory. Under British rule, governors sometimes threatened to slash a judge's pay if he defied the crown. The framers wanted no part of that abuse in the Republic. By locking in pay, they removed one of the most direct levers of political control over the judiciary. Congress can raise salaries for the bench, but it cannot cut them to punish decisions. This structure, one Supreme Court, lifetime tenure, protected pay, is why the court could hand down Marbury v. Madison and declare for the first time that an act of Congress was unconstitutional. It's why Brown v. Board of Education could dismantle racial segregation despite political backlash. It's why United States v. Nixon could force a sitting president to turn over the Watergate tapes. Without Article 3, Section 1 safeguards, each of those rulings could have been crushed by political retaliation. Judges fired, salaries slashed, the court packed with loyalists. Instead, the judiciary stood apart from and above the day-to-day political battle. The founders knew this independence was dangerous. Hamilton admitted the judiciary would be the least dangerous branch in terms of force or will, but the most dangerous if corrupted, because it alone defines the meaning of the law. Article 3, Section 1 is not just about courts. It's about a shield, one meant to guard liberty against both mob rule and executive tyranny. The day that shield bends, The Republic bends with it. One Supreme Court, independent, enduring, essential to the Republic. This is Article 3, Section 1, the last line between liberty and lawlessness. Follow for more of the Constitution. They don't want you to know.